Let's redirect our attention back to the happenings at hand. So, our general counsel, Matt Jacobs, has invited some special guests to lead us through this discussion, and I'm glad to see they've made it down. I hope we didn't, pull them away from any cute otter watching or anything, because we're running a little ahead of schedule. So I appreciate their forbearance on that, and that they've made it down here safe and sound. And I'll hand it over to Matt.
Great. Thank you and good morning. And I'm glad the tap dancing, or the hopeful tap dancing, is no longer needed. This is the session, and I'm pleased to introduce the session on fiduciary duties and sustainability considerations. This is really kind of the idea being here, the intersection or kind of the Venn diagram of sustainability issues writ large and our fiduciary duties as trustees and staff of CalPERS. We're going to be talking about where that intersection is and really what's in it. I'm pleased to introduce my two new best friends, Vaughn Hughes and Tiffany Reeves. Both are really top experts in this area. Vaughn is, as Marcy mentioned at the outset, the CEO of Calvert Research and Management, which is a $40 billion investment management firm that specializes in responsible and sustainable investing. He's the author of an award-winning book in this area called U.S. Public Pension Handbook, a comprehensive guide for trustees and investment staff, McGraw-Hill 2019. And contrary to the little joke that he was making last night, that Jose Luis and his mom were the only ones who had bought copies of this, it's actually been well received and well purchased. Vaughn is also an adjunct professor at the Columbia Business School. Tiffany leads the institutional investor practice at Faegre Drinker, which is about a 1,300 lawyer firm, international firm, and she is based in Minneapolis. Tiffany, as part of her job, advises institutional investor clients on fiduciary, governance, and legislative matters, as well as many other types of matters. She also served a stint as the Deputy Executive Director and Chief Legal Officer at the Chicago Teachers Pension Fund. The presentation this morning is in two parts. We'll open it up for questions after each of the parts. And so with that, I will turn it over to Vaughn and Tiffany, and thank them very much for being here.
Thank you for the introduction. That's actually... Hello? Better. Thank you for the introduction. It actually helped me. That's almost exactly how I scripted it, so that worked out perfectly.
It's nice when those work.
It's perfect.
Yeah.
Henry Jones actually wrote the foreword of my book, and maybe if we have some time at the end, I'll tell you the actual story, because if it wasn't for him, the book would not have been written. So it's actually a pretty interesting story. So can we turn to page 3, just the table of contents? Just want to give you a little overview of what we're going to talk about today. The presentation's in two parts. The first part is fiduciary responsibility, where we're going to go through the primary duties and some of the sub-duties of at least the big fiduciary responsibilities. There'll be some other material that's in the appendix for some of the other fiduciary responsibilities, as we'll discuss, really highlighting what it means to be a fiduciary and the obligations that entails. Then we're actually going to talk about fiduciary responsibility within the context of sustainable investing, and really begin to at least outline a framework through which to look at some of the sustainable activities you've done and are planning to do. There's a lot of information in this book, and a lot of the slides might be heavy on text, and there are more slides in this deck than we're actually going to go through. But at the end of the day, the idea is to have a leave behind. But with that in mind, and given a limited amount of time, we will hold questions to after the first section, and then also after the second session. And I'm pretty sure we'll leave enough time to have a pretty robust discussion either way. So turning to page 6, we can just jump right in, starting with what is a fiduciary. And pretty simply, a fiduciary is any person or entity who makes or has the authority to make discretionary administrative or investment decisions related to the retirement plan, or just very simply any person or entity who's named as a fiduciary. An individual can be a fiduciary by designation or by function. And usually there's a functional test to determine whether or not that individual has the authority or discretion to actually be a fiduciary. Turning to page 7. So who is a fiduciary? Well, first of all board members and trustees are fiduciaries. Certain key executive staff are fiduciaries through board delegation, like the CIO in particular. Other internal staff have delegated authority, and a person's fiduciary responsibility is indeed limited to the scope of that delegation. Investment managers, consultants, are usually fiduciaries. Custodian banks can be fiduciaries for certain functions. Actuaries, attorneys, auditors, brokers are usually not considered fiduciary, and obviously anyone doing administrative or ministerial tasks is not a fiduciary as well. Page 8. The essence of being a fiduciary is essentially being held to a standards of conducts that can and are often found in many different sources. I've listed some of the sources here that are relevant for CalPERS. The primary source of fiduciary responsibility is usually found in the legislative authorization documents, which is in this case the California Constitution, the California state statutes and regulations. Case law is where fiduciary responsibility can also be defined, and it's where courts decide or interpret fiduciary responsibility. And in fact, the restatement of trust is a great summary of current common law, and it is the framework that we're going to talk about fiduciary responsibility through. And I wanted to give you that heads up as well. It's how my book also does it. And finally, ERISA. Although it doesn't apply to public pensions, most public pensions do model their fiduciary standards after ERISA in some fashion, so it always becomes relevant. Page 9, and I'm only going to say one thing on page 9, and that this page just highlights in a little bit more detail the actual California statutes and constitution provisions that constitute your fiduciary responsibility. And turning to page 10. Now, the one question I always get from trustees when I do this tutorial, and this in fact is a fuller tutorial that I do and I've done for a lot of public pensions and also for my class, is trustees come to me and say that fiduciary responsibility is this hard to ascertain concept. It's kind of amorphous. The reality of it is that fiduciary responsibility is not an amorphous concept. It's actually defined by 8 primary duties. And many of those duties have very specific sub-duties. And those 8 duties are prudence, loyalty, impartiality, duty with respect to delegation, duty with respect to co-trustees, duty to furnish information to beneficiaries, duty to segregate and identify trust property, and duty to follow law and plan documents. Now, for the sake of time here, Tiffany and I are only going to talk about the duty of prudence, loyalty, and impartiality. But to be honest with you, many legal scholars believe that all of these duties can be derived from simply the duty of prudence and loyalty alone. So I don't think we're short cutting anything here. And again, as I mentioned before, finally, this framework is a framework that's laid out in the restatement of trusts. On page 11. All of the primary duty pages, the summary pages that we have, are kind of heavy with text. I'm not going to touch upon all of the text, but these are great leave behinds. If you're ever curious about what these individual responsibilities are, they're written in a way that really just walks the reader through. But to start with prudence, one of the fundamental responsibilities of a trustee is to act prudently. And if you dig into it, what does prudence really mean? Well, it's actually broken down into 3 specific separate duties: the duty of care, the duty of skill, and the duty of caution. The duty of care requires a trustee to make reasonable effort and diligence just in doing your job, which essentially means reviewing relevant information, conducting appropriate due diligence and investigation before making any kind of decision. I kind of like to call this a just do your homework rule, very simply. The duty of skill requires a trustee to exercise the skill of an individual of ordinary intelligence to understand the basic duties of trusteeship. And a session like this goes a long way to satisfying part of that duty. and to possess a necessary skill or rely upon competent guidance to satisfy the standard of care. And for those of you who have specialized skill, this duty of skill requires you to actually use it, if it's financial or legal. And I like to call this the if you have it, use it, if not, hire it rule. But again, I think as boards become more sophisticated with financial experts, as well as legal experts and even pension experts, the requirement that those who have an expertise use it is something that's becoming much more focused on in recent times. The duty of caution requires a trustee to exercise caution of a prudent person managing similar assets for similar purposes. And I'd like to call this the proceed with caution in decision-making rule. It's funny, I wrote this book, came out in 2019. I actually had to write it and have it to the publisher by 2018, and I came up with what I thought were these really cute names for these terms, like the do your homework rule and if you have it, use it rule, et cetera. 6 years later, I read these and they're maybe not as funny as I thought they were back then. But at the time, they at least I thought they were. So turning to page 12, to kind of further explain prudence, it's important to understand that the duty of prudence is a test of a trustee's conduct, not the result of that conduct. And it really just depends if a trustee can demonstrate that he or she engaged in the appropriate due diligence before acting. Prudence is evaluated under the circumstances at the time of behavior, and it's not done in hindsight. Now, one of the great things I liked about this presentation is that we really kind of break prudence down into some clear examples, and these examples aren't mine. I am actually not the legal scholar sitting up here. The two to my right are, but these are examples that come straight from restatement of trusts and case law, and are great examples to explain prudence. And I've layered some of these other primary duties with these case laws. So in U.S. v. Mason, trustees were found to have acted imprudently in a real estate purchase because they neither obtained a property valuation nor an appraisal nor participated in any of the negotiations. Trustees in this situation didn't satisfy their duty of care or caution. In another case, trustees acted imprudently in their attempts to commit almost a quarter of the plan's total assets in a single loan. These are extreme examples, but they really begin to drive a point home around prudence. And finally, in White v. Martin, the court found that imprudence cannot be established by evidence only of a loss in investment value of an asset. Again, prudence is a test of conduct, not the result of that conduct. And you do see a lot of lawsuits out there, beneficiaries suing pensions because of losses. Losses in and of itself do not establish the lack of prudence. It's really the decision made around the time of it. I will touch upon this page and turn it over to Tiffany, but to discuss prudence in the context of investing, the restatements codified something called the prudent investor rule. And it really is the application of prudence in investing. The rule established and codified three key common law developments. The first was that the rule replaced ordinary prudence standard with a prudent investor standard, and Tiffany's going to talk about what that heightened prudence level actually means specific to California. The rule also created a positive duty to diversify trust investments and also imposed a duty on trustees to actively monitor investments and make changes as necessary. This was, I know it sounds a little nerdish, but this was one of the most significant developments in trust law and pension management, because it actually codified for the first time modern portfolio management concepts like diversification into public pension management, in this case, pension management. So it was relatively significant. And with that, I'll turn it over to Tiffany to talk about California and the heightened prudence standard.
All right, next slide, please. Well, first of all, thank you for having me the first time I've spoken. So I'm excited to be here. I'm a nerd. I love fiduciary duties and governance and talking about it. So I'm really excited to have this discussion with you. And I'm also a very practical person. And so what I find is that fiduciary training often focuses on what fiduciary duties are, what you cannot do, but it doesn't focus on the how and the why. And so that's one of our goals for this presentation, is to talk about not only what fiduciary duties are, and we'll talk about that right now, and as Vaughn has kind of gone over the basics, but also why they're important, and then the how. That's the governance. That's how you execute your fiduciary duties. So specific to California, you have a prudent expert standard. And that basically requires two things. You're supposed to act under the California Constitution solely in the interest of the participants and beneficiaries, and then with the skill, care, prudence, and diligence under the circumstances that are then prevailing. As Vaughn mentioned, it's not about the outcome, it's about the circumstances under which you make that decision and the information that you had at that moment in time of a prudent person acting in like capacity, familiar with such matters. That means the prudent expert. And both the Public Employee Retirement Law and the Constitution set forth that standard. So if you move on to the next slide, please. Courts have interpreted the prudent expert standard to mean the prudent expert with experience. And that means that if a board member, a trustee, another fiduciary has a specific skill or expertise, if they're a financial expert or a legal expert, the prudent standard requires them to use that skill to inform decision-making and oversight. So I like Vaughn's little short phrases. So if you have a skill, you use it. And if you don't, you hire it. So it's pretty simple. So as I mentioned, prudence is forward-looking. You're not judged in hindsight on the success or failure of a decision from a legal perspective. You might be judged, externally through the media scrutiny or through stakeholder scrutiny on those outcomes. But from a legal liability perspective, you're only judged on the prudence of the process that you undertook when you made that decision. So this means that the dissection of prudence is contextual. It's within the framework of the timing when you made that decision. And that's why our focus is so much on process and diligence and kind of the formality and the accountability that you build into your governance. Next slide, please. So when you think about process and diligence, a very important part of a prudent process is looking at peer practices. And you can define your peers in a lot of different ways for pension funds. It might be other financial institutions. It might be other pension funds. It could be non-US pension funds. And so it's important to look at peer practices as a reference point. But you want to avoid what I call the lemming effect, where you're herding around similar practices and you're all following each other off a cliff, right? Peer practices are an important component of a prudent process. It's not dispositive of your decision. So herding around similar practices should be avoided. It's a data point, a reference point. It's important, but it's not kind of the end all and be all. And we'll talk about this a little bit later in the context of sustainability, but when I'm talking to clients about fiduciary decision making, I like to see a really well-sequenced, thought-out process. Your research and your diligence should inform your goal and your decision-making, not vice versa. And we'll talk about this a little bit later in the context of a case study. But that's also why I'm a huge proponent of frameworks and making frameworks, because that shows that you've undertaken a process to really think about something before you've made a decision. Next slide, please. So the duty of loyalty, as Vaughn mentioned, it's one of your core fiduciary duties. And this is basically because of the fundamental relationship between a trustee and a beneficiary. As I mentioned, in California, you have the exclusive benefit requirement. That's also a core tenet of the duty of loyalty. And the exclusive benefit requirement is what distinguishes pension fiduciaries from every other type of fiduciaries. And you all probably experienced this, and you hear this in the media, that the term fiduciary is a frequent source of confusion, because you hear fiduciary for corporate directors, you hear fiduciaries when you're referencing endowment and foundation fiduciaries. This standard means different things to different types of fiduciaries, also means different things to different fiduciaries in different jurisdictions. So fiduciary duties in Europe or in the UK or in Australia or Canada, even though those are all pension funds, are a different legal standard. And so it's really important to understand the differences when you're looking at peers and what kind of the nuances are in those requirements. And so the key difference between fiduciary duties for a pension fiduciary and a corporate director or a registered investment advisor is the tolerance for conflicts of interest. There is really essentially no tolerance for conflicts of interest under U.S. law for pension fiduciaries. It is the strictest fiduciary standard under the law, which is the key difference between pension fiduciaries and other types of fiduciaries. The duty of loyalty also requires fair dealing, and so you have to deal with your beneficiaries fairly. There's no favoritism among beneficiary groups, and we'll talk about that a little bit more in terms of applying impartiality concepts. Participants and beneficiaries should remain reasonably informed, which means all material facts should be communicated. I like Vaughn's reference here, the don't hustle the beneficiary rules. Make sure they have good information. Transparency is really important, and you'll find that people suffer more in imagination than in reality. This is for your life too, just generally. People suffer more in imagination than in reality. So when you don't give your beneficiaries and other stakeholders good information, they're gonna make it up. Or they're gonna hang on to a seed of information, or maybe they're even committed to misunderstanding. But your role is to be very transparent and give them good information so they don't have to suffer in their imagination. And then the last component is really self-explanatory. Now, no self-dealing. There's no tolerance for conflicts of interest. No transactions for personal gain. Avoid real, actual conflicts and also apparent conflicts of interest, and then also have the foresight to avoid circumstances that could create a future conflict of interest. So a very common duty of loyalty challenge that I see when I'm working with pension fiduciaries across the country is the two-hat rule. We could move on to the next slide, please. So many of you wear two hats as a fiduciary on this board, and maybe even other boards that you sit on. But this is a common challenge for fiduciaries, is that they might wear a stakeholder hat and a fiduciary hat as a trustee, or as a participant and a board member, or as a sponsor or ex officio member, and you have conflicting interests and information and priorities when you're wearing those different hats. And I find that a common misconception is kind of over here to the, I guess, your left here, where fiduciaries think that they're allowed to consider kind of this hierarchy of different interests as long as they also consider beneficiary interests. That's false in the context of a pension fiduciary duty. The duty of loyalty does not permit the hierarchical consideration of varying interest. It only allows you to consider the interest of the beneficiaries. So you have to kind of compartmentalize when you wear two hats. And when you're wearing your fiduciary hat, you can only act in the interest of the participants and the beneficiaries. That's the whole deal. It's all about the beneficiaries. Next slide, please. So, as I mentioned previously, the duty of impartiality derives from the duty of loyalty, and it requires impartiality among individual participants and beneficiaries vis-a-vis other participants, but it also requires intergenerational equity, impartiality between different groups of beneficiaries, not just the individuals. So you might have participants in your system who, a participant in your system who's a 24-year-old new entrant and is just starting their career, and then participants in your system a participant in your system who's a 90-year-old annuitant, and their interests are very different. They may have different exposures to long-term risk and kind of the impact of sustainable considerations on your portfolio over a longer investment horizon. Their interest in the sustainability of the plan is very different. And a common misconception is that you have to kind of balance the interests. I'm sorry, I'm on the next slide already, jumping ahead. But a common misconception is that you have to, that intergenerational equity requires equality. It doesn't. What intergenerational equity requires is the very sophisticated analysis of weighing short-term interests versus long-term interest of whatever kind of the decision point is at hand, and deciding what's in the best interest for the participants and beneficiaries over the time horizon that you deem to be material. So that's a very sophisticated analysis and doesn't require that these interests completely balance. It just requires that you undertake the process of considering all those different interests in the context that you're making that decision. And I think there's also legal guidance from the Supreme Court in this case called Verity v. Howe that supports this analysis. And basically it says that pension trustees have an obligation to preserve assets to satisfy future as well as present claims and take impartial account of all the interests of beneficiaries. And I think an important point from Verity, from the Verity decision, is that this is the first time where you see the Supreme Court really recognize the importance of time horizons to the fiduciary analysis. And we'll talk about this a little bit more in the context of sustainability later too, but it's important to reinforce the overwhelmingly long-term pension fund obligations and that long-term investment horizon considerations should almost always be considered and balanced with short-term needs. So Vaughn's gonna talk a little bit about just kind of summarizing the what for you.
Next page. This is a chart straight from my book, and it summarizes all of the primary duties and their specific obligations or sub-duties. I'd like putting this together primarily because it's a great takeaway where you can very easily refer to each of the responsibilities and obligations that you have under the primary duties. Again, we only covered prudence, loyalty, and impartiality. And I would argue that from prudence and loyalty, you can, derive the others. I kind of spoke very quickly in the beginning, so we have a little bit of time. So as I promised, we wanted to pause here from questions, and then I'll tell you the story about Henry Jones before we move on to the discussion of sustainable investing.
Great, thank you. Very illuminating. I'm sure we'll have some questions, and so we'll begin with Director Pacheco.
Yes. Make sure I get this closer to me. Can you hear me now?
Yes.
All right, good. First of all, thank you, Matt, for those nice, kind words about my mom and me. So, first of all, I wanted to ask a question. Thank you for your presentation. It is very illuminating. Yes, I really do. I am actually a fiduciary nerd myself, so I can tell you that as well. I like to go over the duty of loyalty and that slide to whom, the to whom one, in terms of the actual beneficiaries. And can you elaborate on the? I wrote that. Provide us any hypotheticals or situations of how that applies under the duty of loyalty and to whom.
Want to take up?
Yeah.
Maybe I won't give you a hypothetical. I'll give you a real world situation that's public record. But some of you may have heard a lot about the controversy in Ohio with their state teacher systems, and there's a number of different issues that they're dealing with there. But one issue.
Microphone.
Oh, sorry. One issue relates to the COLA, the cost of living increase. And so they have an unusual structure there where the board has the discretion to set the COLA or to suspend the COLA with the input of an auditor. But it has created kind of this fissure between the retirees and the participants there. And there's a lot of external stakeholder pressure to reinstate the COLA, but their actuaries determined that it's not appropriate for the plan at this time. And so their board is dealing with some very challenging duty of loyalty issues, because there is a caucus of the board that wants to accommodate the needs of the retirees when it's not in the best interest of the plan. And so that's actually probably a better example of a duty of impartiality issue, but that their obligation is not to act on behalf of the noisiest caucus in their stakeholder group. Their obligation is to look at what's in the best interest of the plan over the time horizons that they've determined to be material, which is the long term.
Good.
And is that still, are they still working on that? Or?
Yeah, I mean, working on a number of different ways, and so there's some real dissension happening. I mean, the COLA is suspended, but kind of the drama that has come out of this disconnect and the kind of the infighting between the various factions is that it's created broader cultural issues at the board level, and has created an environment where the Legislative Oversight Council is actually trying to decide whether how to move forward. And I think board composition is something that's on the table, or change in board composition.
Very good then. Thank you very much for those comments.
Thank you. Okay, next, Director Walker.
So I just want to make sure, because how my mind has worked, and I thought I heard you say it, right, that we are on the long time horizon. So when I think of beneficiaries, I think of them in two buckets: our beneficiaries today as they exist, but also our beneficiaries tomorrow, because we have to exist so that they can reap whatever has been promised to them or whatever. Does that make?
Yeah.
So that's yes.
Absolutely.
Okay.
And there's a concept called, and I think you mentioned this, intergenerational fairness. That usually is, the term applying to being fair to beneficiaries today and tomorrow. So, yeah.
Thank you. Just a note, you guys got to hold the microphone real close. They don't pick up much, and they'll keep yelling at you from the back because they can't hear you.
All right. How's that? That's right. That is much better. Wow.
Okay. Okay. And who else do I have?
Any? You,
Ramon?
yeah. Henry Jones. All right.
Ramon?
Yeah, this
There
is
we
it.
go.
This is-
Yeah.
Literally, this is what I've told. Okay, so let's just start off with no one grows up wanting to write a 500-page book about public pensions. So there's got to be a reason why, right? So going back to a time period when I actually had no gray hair, I was having lunch with Henry up in Santa Monica, and I think it was a year or two after his wife had died. And he was, telling me these great stories of her and how he was going to still do his bucket list that they did together. And I'm sitting there enthralled by everything he's saying. I'm rethinking my whole life based on it. And so I'm like, Henry, listen, I'm starting this strategic advisory franchise at our firm, and I'd love to find a way to work with you. We have to build up our credibility, et cetera. What do you need? And let's just do this. And it'll be a way of us practicing, right? He said, well, it's interesting. The board is discussing whether or not we want to publish something called a statement of investment philosophy. So for those around when these conversations took place, this kind of dates this. And he said, can you tell me just what's the difference between a statement of investment philosophy and an investment policy statement in the context of public pensions, and how have they viewed them differently? And I said, it's a good question. I know statements of investment philosophy aren't as common. So let me go back and do some research and come back to you. I went back to my office and I started Googling statements of investment philosophy versus statements of investment policy, and found nothing. Then I started typing in some terms around trustees and investment policy, found stuff, but nothing really, clicked. And then it just occurred to me, there's got to be a handbook on this, right? And I typed in public pension handbook. And sure enough, about 15, 16, 17 books that were titled public pension handbooks came out. Many of them were in late stage editions. And I looked closer though, and they were all in the UK market, which is the second largest public pension market globally. So I said, oh, let me just refine the search and type in U.S. public pension handbook. I did so, and not one single book popped up. And that's when I thought that I'd stumbled upon this great idea, a well-proven concept in the second largest public pension market, and no one had written the book for the U.S. market. So I did what everybody who gets struck by a bolt of lightning for a great idea does. You sit on the idea for about 3 or 4 years. And then at one point, my wife, literally would just come on, she was like, you got to write this book before somebody else does. And sure enough, 1 or 2 things came out that sort of were attempts at trying to do this. And that's what prompted me to write the book. And for those who are interested in writing books, see me later. I can tell you the whole process because I had to learn how to do it from the ground up. It's you do not have to write a whole book. You just have to write a book proposal. But that's the story. And literally, it's only because Henry was nice enough to allow us to find some way of working together that started me down this path. So, and he was gracious enough to write the foreword. So that's the story behind the Henry Jones. So thank you for letting me tell that. And I've gone completely sideways. So let me bring this back a little bit and turning to page 23. Sustainable investing, defining sustainable investing. And what you're really seeing on, well, actually, sorry, were there any other fiduciary questions about fiduciary responsibility at all? Okay, and
I'm
again,
seeing none, so continue.
okay, if something comes up and it's tied to this, we can address that as well. The word cloud on this page is really meant to just highlight that there are a number of terms and approaches around or under the umbrella of sustainable investing that you hear and are used today. And to really get your arms around this actually ever increasing cloud, you really can think about sustainable investing as a catch-all phrase, encompassing all approaches that in some way consider environmental, social, and governance, the E, the S, and the G, factors in investment decision-making. It's typically in investment decision-making with an idea towards managing risk, capturing sustainable opportunities, or for that matter, furthering positive environmental or social change. So, it's important to kind of understand that I actually wanted to add one term to this word cloud that's not technically up there. It kind of is up there in pieces, and that is what being a responsible investor is. Because I think there's an article that came out today in the Wall Street Journal about backlash against the term ESG and how it's moved into sustainable investing and being a responsible investor. And I agree. And just so you know, that's not a surprise. In my business, we have stopped effectively using ESG as well and really talked about sustainable investing and, more importantly, being a responsible investor. And that's what you should focus on, because I think being a responsible investor is not only a function of implementing some sustainable investing approach. In the next page, we'll talk about some high-level approaches. This is, you can have a whole session on just sustainable investing, but at least we'll touch upon some to put within a fiduciary framework. But it's also incumbent upon responsible investors to be active owners, true stewards of capital, and act on encouraging ESG improvement in portfolio companies through active engagement and dialogue with company management and even potential proxy voting. So really, when you think about the modern terminology of being a responsible investor, it's both the investing side and the engagement side. And that's important. And that's kind of where some of the terminology is headed today. Turning to the next page. Again, this is a very quick, high-level summary of approaches to sustainable investing. I'm sure in due time you'll get much more down into the weeds about these approaches. But the top half of the page really highlights the 5 approaches to sustainable investing: restrictive screening, ESG integration, thematic investments, impact investing, and engagements, which you're of this probably the most familiar with. From left to right, it really starts with approaches that minimize negative ESG impacts, decarbonization, et cetera, going towards maximizing positive target ESG impacts. And I'll explain a little bit about what that means. But to touch upon each very briefly, restrictive screening, which is, by the way, where ESG investing, sustainable investing began, really with religious-based entities who excluded certain investments and names based upon fundamental beliefs. This is where the concept of sin stocks came from, and this is really the genesis of sustainable investing. But restrictive screening intentionally avoids investments in certain sectors or issues based on values and risk-based criteria. This is where you get fossil fuel exclusions, and again, the exclusion of sin stocks like firearms, tobaccos, and other things. ESG integration considers ESG factors alongside traditional financial analysis to really identify risk and opportunities. This is a very common bucket right now. Thematic investment, really tilting investments towards certain themes or sectors to solve specific global sustainability related challenges like climate change, or for that water, clean water. And impact investing, which is really investing to deliver a specific and measurable set of positive social and/or environmental impacts. It's really with intentionality behind the investment and also a willingness to sacrifice or make secondary return objectives. And that's something I'll come back to. I mentioned this before, but there are three primary reasons or primary goals of sustainable investing. The first is to manage ESG risk, manage risk due to the energy transition, managing physical risk, managing transition risk, for example. The second is actually just improving the ESG quality of your portfolio companies are just affecting positive global change. And the final one is actually capturing ESG opportunities. The energy transition in particular is really creating interesting opportunities for investment, around clean tech and other emerging technologies that are going to fund and encourage this energy transition. And I won't spend a lot of time on engagement since I know you actually had a pretty big presentation on that yesterday. But the bottom half of this chart, of this page, really just takes the approaches to sustainable investing and categorizes them around the primary three goals of sustainable investing, with the idea being that ESG integration and engagement are typically the two approaches that most commonly can satisfy all three of the sustainable goals. One thing I did want to highlight, and Matt was very clear to make sure I highlighted because, and I've already touched upon this in impact investing, not all approaches to sustainable investing fall squarely within an asset owner's fiduciary responsibility. And that's important to understand. And the easiest example is impact investing. When you're investing in funds or managers or properties that have a very clear, defined, an objective, social, environmental purpose, but can explicitly put return objectives, make those secondary. These might be great for NGOs and nonprofits, and in fact, it's impact investing is a key to supporting many of the initiatives around sustainability. That having been said, it is always a challenge to have this type of investing fit within the fiduciary responsibility of an asset owner. And that's something that, you'll have to evaluate. And again, Tiffany's going to talk a little bit more about the framework around thinking through some of these investments. But the other clear thing, I could probably mention one or two restrictive screens as well that would be challenging to fit within a fiduciary framework. So again, just because there is sustainable investing doesn't necessarily mean that all approaches to sustainable investing fit within a fiduciary framework. Turning to page 25. This page shows the results of an asset owner survey on how they're approaching sustainable investing. And to be fair, it's from 2020. So 4 years in responsible investing is like a lifetime. So these percentages have probably shifted a bit. But the takeaway is the same. And that simple takeaway is that institutional investors, asset owners, they all choose different ways of approaching sustainable investing. And it's more often than not a combination of many of the different approaches that we have discussed. Large plans probably have led with engagement, tracing its roots back to shareholder activism of the past. Smaller public plans want to engage and want to punch above their weight in engagement, and because of internal resources are limited in what they can do. So when you think about what asset owners and institutional investors do and their different approaches, is all going to be based on investment policy, internal resources and infrastructure, and just actual portfolio goals. But the takeaways at the end of the day, there's no one way to do it. And every large asset owner has to construct their own plan, and through a process and documentation, support it with what we're going to talk a little bit later about financial materiality. I think that's all I had. Did you want to?
Sure.
Yeah.
So, and just to put a finer point on what Vaughn was saying about different types of investors, is I find that a lot of the criticism and misunderstanding around sustainability and fiduciaries is a lack of understanding of the nuance of different types of fiduciaries combined with the semantic issue with ESG. It means different things to different people. And so I think it's really important to be clear about what you're doing and what you're not doing. And so I travel all over the country, work with lots of different types of pension funds. I'm not aware of any pension funds in the US that are impact investing. But that's sometimes a narrative because it's a confusion about what you're actually doing. What I see public pension funds in the US doing is ESG integration, sustainable investing, and then also systems level investing when you're thinking about your stewardship programs and how to kind of manage non-diversifiable risk. And so I think it's important really to be really clear and transparent about what you're doing, because there is some confusion in the marketplace about what's actually happening with public pension funds. And again, some parties are committed to misunderstanding what's actually happening with public pension funds.
Let me just say one thing, and that's a good point. Where is the public pension universe on sustainable investing right now? Those who are ahead or about where CalPERS is, which is announcing a policy, some targets, and have made some preliminary investments or have earmarked having looked through their portfolio and realizing they actually have made some sustainable investments in the past. Very few public pensions are further ahead in terms of, and that would only be in terms of the number of actual investments that have been made. Any of these investments have all been index focused, very basic equity. There's the beginning to do a little bit more on the fixed income side. The reason why equity came first, it's hard to, it's possible, but very hard to tie engagement to fixed income, or harder to tie to fixed income. So a lot of this starts with investing. There are a large number of public pensions that either through state or legislative mandate are required to decarbonize specifically, who have either just minted or about to mint formal policy statements around sustainable investing. So I just want you to know that CalPERS continues to not only take the lead, but I think, as always is the case, the more that CalPERS does, the more that other public pensions will, in turn, typically follow. And you've seen that in almost every single asset class. Not that this is an asset class, more an investment approach, but that's important to understand. And I'm sure one of the questions is going to be some of the politics around this, but we can get to that later. Sorry.
Next slide, please. So as we mentioned when we were laying the foundation about what fiduciary duties are, pension fund obligations are overwhelmingly long-term by nature. Long-term investment considerations should almost also be considered and balanced against the short-term needs of the plan. And so this means that sustainability considerations are wholly consistent with the duty of prudence and the duty of loyalty, because the whole purpose of a pension is to provide for present and future benefits. So material sustainability considerations are relevant to risk and then also to return opportunities. And we'll talk a little bit about the Department of Labor guidance on that in just a moment. But first, I wanted to revisit the restatement. And if you can go to the next slide, please. So the restatement of trust is a really important source of fiduciary guidance. And it often informs court decisions on fiduciary duties where there's an ambiguity or the law doesn't address a certain issue. And so it kind of helps fill the gap. And Vaughn mentioned before that with the restatement third, it has evolved over time to accommodate. Oh, I thought you were going to tell me give me the hook, the hook on time. I was like, oh no, am I over time? So it's evolved over time to accommodate the evolution in the way that we invest. You know, we've come a really long way from 60-40 portfolios and statutory list of required investments. The analysis is so much more sophisticated than it used to be. And so trust law has had to evolve over time to accommodate, you know, kind of changing circumstances. And the restatement cautions us that fiduciary duties have to be flexible and should continue to evolve and as knowledge and circumstances change. And it cautions fiduciaries that you should avoid freezing your rules against future learning. And I think we've even in our own, you know, the last probably 15 plus years that I've been talking about sustainability issues to fiduciaries, we've seen those issues evolve over time, and there's greater and better information at this point. So it's important to note that the restatement supports the notion that prudence evolves over time. Next slide, please. So this just puts a finer point on it, that the, you know, obviously there's increasing complexity in portfolios and risk management practice, and there are no universally accepted or even enduring theories of financial markets. And so as circumstances change and knowledge advances, the approach to investing will change as well. When I first started looking at this issue, as I mentioned quite a while ago, I would say the common approach for fiduciaries who were even thinking about ESG 15 years ago, a lot of them were not, but the common approach was what I call ESG in a box, right? And so it was to take a little small part of your portfolio, the discrete part of your portfolio, and kind of beta test it against some of the information that you had. So maybe you know, integrating ESG considerations based on the limited data that you might have had at that point, or looking at it through a lens of innovation. And obviously information has really gotten a lot better over the last 15 years. And so fiduciaries are now kind of thinking about sustainability risks and opportunity from a total portfolio perspective. And that has changed over time as we've had better information and seen the evolving approaches of other investors as well. So, you know, just as sustainability approaches have evolved over time, we've also seen the regulatory guidance as it relates to sustainability evolve over time as well. And so, for context, the Department of Labor issues the rules that impact investment of ERISA fund assets. And even though the Department of Labor rules are not binding authority for governmental plans, or state investment boards, the Department of Labor influences how other investors are thinking about fiduciary duties, and it helps to kind of fill the gaps and helps us to understand how courts might interpret the guardrails for fiduciary duties and the types of investments that fiduciaries can consider. So the prior guidance from the Department of Labor has been kind of like this whiplash over the last, you know, probably almost 35 years, if not longer. And so it's kind of been this pendulum shift of regulatory guidance. So with each successive administration, you take one step in, you know, a few steps in one direction, and then the administration changes and you take a few steps in the other direction. And so this kind of pendulum shifting of regulatory guidance has left a lot of investors in kind of this holding pattern, kind of waiting for the dust to settle and waiting for clarity about what their obligations are. And so the old guidance derived from this kind of old socially responsible investing perspective, the idea that ESG considerations were considered to be moral and not financial. And that kind of presumption, I think, tends to pervade some of the discussions around sustainability issues. The old guidance basically said that if all financial considerations were equal, then you can consider ESG as an option. There was this old kind of tiebreaker test that kind of had this maybe unrealistic hypothetical that you would have two equally appropriate, financial or investment options, and then one would be sustainable or incorporate ESG issues. And I don't know how realistic that is, but that was kind of the old guidance that persisted for 30 years. But under the new rule, the requirement is basically that if there are competing investment options that equally serve the investment, if there are two competing investment options that equally serve the financial interest of the plan, you can consider the one that also has collateral benefits. So kind of fast forward to the current time, or the most recent times. In 2020, we saw a fiduciary rule under the prior administration that essentially shifted the burden back to fiduciaries to demonstrate that ESG was a pecuniary factor. So to demonstrate that they prudently determined that the factor was expected to have a material effect on risk and return. So basically shifting the burden to fiduciaries to prove that a factor was material to risk and return. And so in 2021, when the administration changed, they quickly decommissioned this rule and then went through a process of study and adopted the 22 guidance, which, so basically after like 30 years of this pendulum shifting of regulatory guidance, the 2022 rule basically allows fiduciaries to use their discretion the same way and treat ESG factors the same way that you would treat any other traditional material risk or return factor. So let me say that again. It basically, the current rule in the current state of law is that a fiduciary can simply use their discretion the same way they do in any other investment decision to evaluate how a course of action or inaction is material to investment value. So to me, that's like the radical application of common sense, right? You're a fiduciary, you have discretion, you can use it to make investment decisions. So the ESG rule under the Department of Labor also expressly allows fiduciaries to treat material climate change and other ESG issues, I already said that, the same way that you would treat material risk and return factors. So what I mean by that is that if a fiduciary undertakes a prudent process, and then based on their diligence, they reasonably determine that climate change or another ESG factor is material to investment risk or return, the fiduciary may consider it. And what I think is interesting about the rule is if you looked at the proposed rule, it said the fiduciary should consider it. And after a lot of discussion and debate, they walk that back because the intent of the rule is not to put a thumb on the scale. The intent of the rule is really to defer to fiduciaries to make that decision. So it's pretty simple. If the Department of Labor is saying that ESG and sustainability considerations are a secular issue, they're not going to put their thumb on the scale. If you determine in your discretion that's been given to you by, the authority given to you by state statute, if you determine that an ESG factor is material to risk or return, then you can consider it.
Let me throw out a question here. Some people might say the 2020 and the 2022 rules or articulation of the same rule aren't really very different because they both focus on pecuniary, the factor of pecuniary, the aspect of pecuniary return. So 2020 says, they're articulated a little bit differently, but no subordination of returns in favor of non-pecuniary. And 2022 says you can consider these things where they're relevant to the risk return analysis, which is essentially pecuniary. So I don't see, or let's put it in a third person context, one might not see a great difference between these two because they both continue to focus on you can consider anything that's pecuniarily relevant. What do you think?
Well, I think they're different. And so my interpretation of the 2020 rule, the prior administration rule, is that they really were tipping the scale in
Burden of proof.
yeah, it was a shifting burden of proof. And so basically they were making it more difficult for fiduciaries to consider ESG considerations, and they were tipping the scale in that direction. And so they had certain onerous record-keeping requirements. There were other I'm trying to think of how to describe that. There was other things in the rule that made it more difficult or less clear about the kind of the scope of what trustees can consider. And so it was very kind of discreet, but the intent, or the apparent intent, was just to make it more restrictive. Does that answer your question?
Sure. Yeah.
The other thing about the current rule is that it reinforces the importance of time horizons to inform the analysis. And this is kind of an issue that I think is often missing from the debate about sustainability and about ESG considerations, is short-term versus long-term. But the current rule really reinforces the importance of time horizons. And while it doesn't explicitly address impartiality, it does reinforce the overwhelmingly long-term nature of pension fund obligations, and that long-term considerations should almost always be balanced with short-term needs. And we talked a little bit earlier about Verity v. Howe and the Supreme Court decision there that recognized the duty of impartiality. And so as long as a fiduciary undertakes a prudent process and then based on their diligence determines that climate change or any other ESG factors is a material investment consideration, then the fiduciary may consider it. The other important thing about the 2020 rule is how it addresses shareholder rights. And so basically the 2020 rule just reinforces the prior Department of Labor guidance that finds that when plan assets include stock, the fiduciary has a duty to manage those assets. And that duty to manage the assets of the plan includes the obligation to manage the shareholder rights that are attendant to those shares, including voting proxies. And so somewhat back to what Matt was referencing in terms of the 2020 rule versus the 2022 rule, the 2020 rule had certain the safe harbors in it that implied a very restrictive use of proxies. So there was a safe harbor, for example, where proposals were expected to have a material effect on value, or there was a safe harbor for not voting proxies, where that holding relative to your total portfolio was below a certain threshold. And so there was a certain kind of overlay with it that provided some comfort for investors to not exercise their proxy rights. Whereas 2022, the current guidance really walks that back. And the 2020 guidance also eliminates a lot of those onerous record-keeping requirements with respect to proxy voting activities. And the concern with the prior administration guidance was that the record-keeping requirements make it more difficult because you're expending time and resources to keep these very specific records about how you're proxy voting. And the concern with that rule is that requiring these very specific and onerous requirements would have a chilling effect on proxy voting because it would make it administratively more challenging. That being said, it's important to document your process. It's important to be formal and accountable to your process, but the law is no longer as prescriptive. One thing that I wanted to mention just kind of broadly from a regulatory perspective is that the current state of the law is obviously somewhat in flux. So you've seen that change from administration to administration. If we were to have a change of administration this year, you would expect that the 22 guidance would be somewhat walked back. and perhaps there would be a reversion to a pecuniary standard. Also, the recent court decision overturning really kind of decades of precedents, our precedent deferring to regulatory agencies to interpret areas where there are gaps or ambiguities in federal statutes might impact the interpretation of the Department of Labor rules. And so the end of the Chevron deference, as we call it, could have some far-reaching implications. And we know even in Texas, there was a case challenging the current Department of Labor rules that was dismissed in reliance on Chevron deference. And so with the precedent being overturned in terms of Chevron deference, we expect that there might be a renewed appetite for challenging the current ESG regulations. So this is the current state of law, but we expect that we might continue to be whipsawed around as Supreme Court precedent and also changing administrations might impact the regulatory approach to this.
Okay, you want to skip, I think, to 31, and I think we've kind of, kicked financial materiality enough, but so I'm not going to say anything other than the key takeaway is that considering financially material ESG factors falls squarely within our understanding of fiduciary responsibility. Again, financial material ESG factors can be considered within the scope of one's and asset owners' fiduciary responsibility. And again, I would probably even argue, and I was unaware of the drafting change in the recent rule, I would even argue that if ESG factors are financially material, then fiduciary responsibility actually, I could argue, requires you to take these into consideration, and maybe one day we won't be thinking about ESG factors as anything different than any other traditional form of, investment analysis. But today,
I think that's what I would what I would agree with
Yeah.
at the bottom line. And then to put just a bit of an addition to it, it's document.
It's document,
the decisions,
document.
because whether it's under the 2020 rule or the 2022 rule, you've got to document it.
Yep.
Under 2020, maybe you had to document it more than you have to under 2022 rule, but still, you got to document it. As long as you document it, you're in good shape.
We have at our firm, we have an extremely complex governance framework because we invested with a data team in actually quantitatively tying financially material factors that went into our evaluation of companies and the eligibility for our investment to really do just that, which is to document very clearly why we're making decisions on financial materiality and when those decisions change. So again, we're doing it going back to 2013, 2014. We were the first to create a system around that, and it's all about the process.
Next slide, please.
We have a question from Director Gallegos.
To your point on documentation and embedding it in the process, improving it, have you seen any performance comparisons of those plans, U.S. public pension plans, who have affirmed sustainability practices versus not? Granted, it's I would say fairly short time period, maybe 5 years you could find, maybe 7.
I don't think the level of investment at the public pension level is enough to impact the overall returns. I think you could probably find some evidence of product by product. But as of right now, I am unaware of any public pension that is investing in sustainable or through a sustainable lens, through ESG integration, that's investing to a scope to actually affect overall plan returns. But I think what you can find is product by product comparisons. And, and to be fair, I think based on market conditions, you're going to see the mixed, for a number of reasons, which are a little bit more complicated, but yeah.
Tiffany, did you have anything to add?
Oh, no,
Okay.
no. I think that's accurate. And also portfolio composition is so different. It's really kind of apples to oranges comparisons across public pension funds. And also liabilities are so different. So investors invest, it's one size one in terms of how investors invest. And so it'd be really kind of difficult to do that comparison.
Yeah. Just one other thing, just to put in perspective, I've yet to have my firm participate in a search where the primary question wasn't how our performance stacked up against either non-sustainable index or a tailored sustainable index, but it's a performance-led discussion, knowing for a fact that we're managing ESG risks. So
My guess is it's a product that is
yeah, no, it is.
to be
And-
developed.
Yeah, and I'll go back and see if I can find something that might done. But again, it's new.
So just kind of the last few slides to wrap up this discussion. As I mentioned previously, fiduciaries should treat ESG the same way that they treat any other relevant risk or return factors. Sustainability is a secular issue. It's about using information to inform action or inaction. I don't think that anybody with a straight face could tell you that you shouldn't use information to inform your decisions. That's what it is. That's basically what we're talking about. I'm very basic and linear. And so I really like this framework for investors. What, why, and how. Investors should communicate their process. What are you doing? And then why are you doing it? If your answer is anything other than it's in the best interest of the participants and beneficiaries over the time horizon that you've determined to be material, if there's anything other than that that's defining your why, then you have a fiduciary challenge. And we would have to kind of consider that in the total context. But as we mentioned earlier, it's the whole circle. It's all about the beneficiaries. So if the why is something else, then you have a fiduciary problem if you're a public pension fiduciary. And then finally, the how. How are you implementing this course of action? What diligence have you done to inform the decision? So it just brings it all back to the basics. It's all about the beneficiaries. Be mindful of your process. So next slide, please. So I think that case studies are always really helpful to see how similarly situated fiduciaries have kind of grappled with some of these issues. And this case study gives a really stark example of two pension systems that were faced with external pressure and took very different approaches to divestment. And then they ended up with two very different outcomes. One was well researched, well sequenced, disciplined, and kind of prudently structured to be formal and transparent, where the other one, in my opinion, put the cart a little bit before the horse. I don't know what their motivations were. I don't know, what information they had at that time, but it wasn't necessarily a credible outcome. If we can wait just a moment before we populate that. So, and it's funny because I remember seeing these two cases probably 5 or 6 years ago and thinking, I'm a little concerned about this one from a fiduciary perspective. And I remember giving a presentation to the board at the time saying, don't do this. And so it's interesting where it ended up. But digging into the details a little bit is the state fund example. So the state fund faced external pressure to divest. They had several different stakeholders and external groups that were pressuring them to remove certain high emissions assets from their portfolio. And I think that the inflection point for them compared to the other example is they kind of had a choice. Are we fearful or are we curious? And I encourage you, like in any decision making, but even in your life, to turn towards that curiosity rather than the fear. And so when they were faced with this external pressure, they basically had to figure out where to start. And so the state fund decided to basically find the smartest people in the room and get curious about this issue and to learn more. And you can continue clicking through. Sorry, I'm not controlling these. So what they did is they formed a decarbonation advisory panel, which was a panel of 6 independent experts to identify and assess the investment risks and opportunities related to climate change. And then also advise the fund on how to prepare for the transition to a low carbon economy. Education, consulting outside experts. The panel then, did their due diligence. They met, over the course of, I think, a year and a half, and produced a comprehensive report on the issue where they reached consensus on most of the points. And then they also had some dissension. And there were some things that they didn't agree about. And they prepared an alternative submission in those areas. The panel then made recommendations that informed their 2019 Climate Action Plan, which included identification and assessment of risks and opportunities, and also investment and divestment of assets. And the third prong was an engagement and advocacy with those companies that they determined were underperforming. Engagement with companies, regulators, and then also policymakers. The Climate Action Plan was formal and research. It included enhanced climate risk assessment for the sectors where they have undertaken a process to determine that those were high risk, and including an in-depth review and analysis of certain subsectors and assets, oil sands, integrated oil and gas, et cetera. And then after conducting these reviews, they developed minimum standards and key performance indicators, formal, accountable. And then they determined that by a certain time frame, theirs was 2025, if based on these minimum standards, they determined that certain companies weren't suitable for their portfolio, they would either underweight them or divest of those assets. So the minimum standards basically baked divestment into a certain component of the process, but only after they had done a full due diligence to inform that investment action. And then finally, back to the transparency point, they reported this process out. So everybody knew what they were doing. And they have continued to replicate this process over the years. At the time, the key fiduciary said that divestment is a last resort, but it's a tool that we can apply to companies consistently, that consistently put our long-term risk at value. So their goal was not divestment. Their goal was to let the information lead them to the right outcome that was appropriate for their portfolio. So in contrast, we have the city funds. And this process really juxtaposes against the other process where some key political figures that were trustees on the board basically were faced with external pressure to divest, and they kind of leaned into that pressure. And so they immediately made a statement committing to divest public pensions from fossil fuel reserves within 5 years. And then there was some dissension, and some of the fiduciaries kind of rejected this approach, but ultimately they decided that some of the funds would divest. Then they undertook a process of analysis to look at the portfolio's exposure to fossil fuels, stranded asset risk, and other climate risk. So they made a decision, and then they undertook their analysis. How do we feel about that sequence? And then they retained an independent expert to undertake a comprehensive analysis to establish, amongst other things, the prudent nature of the divestment action that they had already adopted. I like that, right? Kind of, that seems problematic when you're reverse engineering prudence. And so you're hiring an expert to tell you that what you did 6 months ago was prudent. And then eventually the outcome was that some of the funds divested about $4 billion in assets for fossil fuels. And as fiduciary counsel, I thought some of the statements that were made at the time were somewhat cringeworthy when you're thinking about the duty of loyalty. And so, for example, one of the statements was public statements was our first in nation divestment is literally putting our money where our mouth is when it comes to climate change. Divestment is a bold investment in our children, grandchildren, and the planet. What is missing from that statement, from my perspective, is a discussion of the beneficiaries. I'm not casting dispersions or judging those goals from a personal perspective, but that statement is really missing the focus on that circle, beneficiaries. And I think it's concerning. And I think that it's important to note that, not surprisingly, 4 years later, there was a lawsuit. And basically the lawsuit claimed, among other things, a breach of fiduciary duties, and that the trustees were pursuing goals that were other than that were inconsistent with their duty of loyalty and their duty of care. Now, this case was just dismissed 2 weeks ago on procedural grounds, and basically the court found that the plaintiffs that they lacked standing. You're probably more informed on this case too, so feel free to chime in. But that they lacked standing because it was a defined benefit plan, that these actions did not impact the benefit. There was no monetary loss, because their benefit just basically doesn't change based on investment performance. This was an appellate decision. We expect there to be another appeal, and this is a well-funded case. And so we expect that this litigation will be ongoing. But as of the current state is that it's just recently been dismissed. Is there anything you wanted to add?
No, mild correction that it was at the trial court that the case was dismissed, but we definitely expect it to be appealed. It's, well-funded, as you said, prominent funder, prominent law firm. So
A microphone, Matt.
I'm sorry. Yeah, I'm sure there's more to come on that one.
So I think that you'll note that a lot of the claims in the city funds case could have been preempted by an appropriately sequenced and transparent process of diligence and analysis. And I think it's just a good example of two very different approaches. And the outcome may have been, and probably was to a certain extent, the same. But the scrutiny that led to the litigation was the process. And so, I view the state funds approach as a really thoughtful, robust, and well-sequenced process. And that just kind of brings us back to the decision tree and clarifying the what, the why, and the how. If you're on the right side here, and you're talking about the children and the environment and all these things that are outside of your fiduciary duties, I think you have a problem with the why. The what, the why, and the how, it's a feedback loop, and it's going to keep, and it should be a part of your process. Next slide, please. I'll just touch on this briefly. I don't know where we're at.
That's a great case study, by the way.
Oh, thank you.
That is a really good case study.
So this is a framework for a fiduciary process. This is something that it's not intended to be prescriptive, excuse me. But the goal is just to kind of show you what a thought out process looks like, and that it should be structured and documented and well sequenced, and you shouldn't put the cart before the horse. You have to do the work to inform your decisions. You cannot reverse engineer prudence. The city funds cases showed us if you reverse engineer prudence, you have a very real litigation risk. And so, your process should start with diligence. You should consult outside experts. You should clearly define your goals, objectives, and policies, and those should inform your strategies. It should be the right structure for your organization with the right resources. And then, consistent with your fiduciary duties, you should prudently select and instruct delegates. And then finally, the one important step is oversight, exercising appropriate oversight. I think it's the CFA framework that uses the word superintend for investment oversight. And I like that. That means to oversee with formality and accountability. And so it's important to demonstrate kind of the process and even how you oversee your delegates. And then finally, independent reassurance is an important part of the process. And again, this isn't intended to be prescriptive. It's just to show you, kind of put a finer point on how the state fund worked and really had a very thoughtful, well mapped out process and sequence, which I think really held up to public scrutiny. How are we doing on timing?
We're getting close. I think we want to get toward Q&A.
You want to do last slides or? Okay. Let's move on to Q&A then. What questions do you have?
Okay. Where shall we start? No questions? Seriously? Okay. Well, I will jump in, get things started a little bit. When we come to this issue of outside experts and as fiduciaries, trustees, how could you elaborate a little bit on how you see our role in terms of what our expectations should be in terms of outside experts, how they're chosen, how they're brought in? Because, I've seen experts on, all sides of issues, ranging from, climate changes, fake news, pushed on us by people with a political agenda, to it's the existential threat and nothing matters but carbon. So as trustees with various backgrounds, how do we kind of work with staff to manage our expectations for our need for experts and expert advice and counsel on these kind of issues and decisions, since we have some wonderful experts here to opine on that matter?
Stick to the science. Those who are more inclined to be speaking from a political perspective typically are doing so without hard evidence. Those who are typically supportive of the issues behind climate change usually come to the table with hard numbers. And at the end of the day, your fiduciary responsibility requires you to do the type of due diligence, and it's based on science. And I don't think it's really all that complicated in today's marketplace to understand who's speaking from a science point of view and who's speaking from a political point of view. And I think that intuitive gut can also be helpful, but the real guidance here is just stick to the science.
I think the other thing I would add is that you seek out diversity in perspective as well. And so based on people who are well credentialed and have, there's ways that you can determine the credibility. But one thing I talk about a lot and think about a lot in my work is bias. And financial, behavioral finance theory finds that investors and decision makers are rational, but subject to certain decision-making biases. And so you have confirmation bias, you have herding bias, you have I'm not biased bias. This is something I heard from Adam Grant this week. It's like that a lot of people think that a bias that we have is that we're not biased. And so I think when you're consulting outside experts, it's important to seek out diverse and even contrarian sometimes views so that you have the best kind of portfolio of information to inform your decision. But again, with people with appropriate credentials.
Thank you. Anyone else? Director Pacheco?
Well, thank you very much for this second part of the presentation. I want to go back to the state fund and the formation after the external pressure to divest from various stakeholders. What was the roots of the decarbonization advisory panel, and what did it do? I mean, what was the charter statement? I'm just kind of trying to understand that process, because I want to understand how that led to the climate action plan and so forth. You guys can elaborate a little more. Thank you.
Yeah, I don't know how much additional information at my fingertips. I can certainly provide it. But my understanding of it, and this kind of goes to your point as well, is that it was a panel of diverse experts and academics, investment experts. I think there was a couple of people on the panel that were from Canadian asset managers. So some diversity geographically as well. And I mean, I think that's kind of indicative of the broader importance of diversity and diverse perspectives, is that they all were credible experts. They were all independent. And I think I mentioned in the presentation as well, is that they didn't agree on everything. But they kind of coalesced around a few key determinations.
If I think this is the case study I'm thinking it is, what that group did is laid the rationale for the subsequent policies that they came out with, laying out the financial material impact that carbon was having on the environment, and more importantly on their portfolio, and that it represented a very material risk that had to be accounted for today's generation and tomorrow's generation. So it's laying the actual research-based foundation for the policy decisions that they made.
And that research base there was a variety of domain expertise.
exactly.
I mean, not from different perspectives.
Yeah.
That landed to where it would go to this process.
Exactly.
So that's a really interesting model.
One thing I might add on the question of expertise and who you might hire, who you might turn to, is you can actually get experts on the process itself. That is, in designing of the process and in whether your process will meet whatever standards that you are trying to meet. And it's not just lawyers, although it could certainly be lawyers like the three of us, other lawyers, fiduciary lawyers, but it could be other consultants as well. But just the point is, on designing the process and in implementing the process to ensure that it's a healthy and process that will withstand scrutiny from whomever may scrutinize it later.
Yes, and that would be under the prudence of caution, to be very prudent and be very thorough about
Care,
care,
caution, skill even.
skill.
Since you
Yes.
didn't have it, you went out and got it. Yeah.
Very good thing. Thank you. Those are my comments.
Thank you. Director Ortega.
Thank you. I had a question. Early on, you mentioned different fiduciary standards in different countries. And I wondered if you have any examples or there's anything that might be of interest to us about how that different standard has resulted in different approaches to sustainability.
You know, I can get back to you with that. I know the prudence standard in the UK, and in fact, our fiduciary framework kind of goes back to English law. That having been said, ours has kind of evolved beyond where the UK is. I do know that, for better and worse. You would argue that because of where our prudence standard is, you would see a different board composition than you would see in the UK, but you actually don't. It's pretty consistent with, in general, an increase in investment expertise over the years and an increase in legal expertise, but the differential is not significant enough to tie it back to any change in the prudence standard. In terms of sustainability, let's just put everything in perspective. The United States is behind the rest of the world. The rest of the world is significantly further ahead in being able to accept and process issues around climate change, as well as other sustainable issues. And, I firmly believe that over time, the U.S. will catch up. The politics will play itself out, but over time, the U.S. Will catch up. So even though they might have a prudent standard that would, in theory, make it more difficult to accept some of this, they're significantly further ahead. And I just want to put that in the context so, we don't think about climate change or any environmental or social issue from a purely U.S. perspective, but from a global perspective, whereas we are probably playing a fair bit of catch up for a number of reasons. So I know that doesn't specifically answer your question. I can come back with more examples of I'm just not an expert in international fiduciary standards. She said she was. Why don't you ask her? No, I'm kidding.
No, I did not say that. But one thing I just wanted to add is that we've seen cases in non-U.S. jurisdictions that are really the inverse of that, is it Wang case? And so Wong, so we've seen in Australia and in the UK, breach of fiduciary duties claims that were founded in the board's failure to consider climate specifically in their investment decision making. And neither of those cases came to a decision. One was dismissed and the one in Australia was settled. But you are seeing the kind of inverse of the US litigation in the UK and Australia, and we've seen that historically.
Okay. Oh, Director Walker.
Thank you. I just wanted to say that I really appreciate your process wheel.
It's great.
Because it makes a lot of sense to me. It makes, I think it makes it easier it's how my mind works. How do you think about things, right? Which way do you go? And it's less about right or wrong, but more about following the process. And if you do that, more things come to light, I think, that help you to make your decisions, right? Instead of saying, oh, I want this, like the other one where they said, this is where I want to be. And now you give me the roadmap to get there. It makes a difference. So I really appreciate the process wheel. We should print that out, have it plastered everywhere.
Yeah, no, I would say tie that to the case study that she did, and that I will be copying that. I'm just telling you now.
Put my name on it.
Yeah, exactly. I would also like to highlight that, and this first time I'm realizing it, that case study of effective implementation of sustainable investing is actually mirrors the case study that I teach at Columbia Business School on just pension reform in general, where the way they sought out, the evidentiary foundation, created a policy, gathered stakeholders together, established rules, implemented, reported, is almost a case study at how public pensions in particular change how they act. So it's seeing the electronics behind it reminded me that there's something very significant to how to do things right at a public pension. There is a way of doing it, and that is a great case study to highlight that.
Well, and then one other thing too around process is that a court is not going to look at whether your process is right or wrong. That is not the analysis from a legal perspective. What the court's going to look at is whether your process was reasonable under the circumstances. And so that's why it's not, I like it too because I came up with it, but it's not, it doesn't have to be this process, but it's about whether you, in your discretion, determine that your process is reasonable. The court is not going to dissect whether it was right or wrong. They're not going to look at the outcome.
Yeah.
So there's always been where people try to seek a legislative solution to a fund, right? And so I get once the legislature, if they pass something, it's the law. But how do we react? How do we respond? What do we do? Because it can be totally, I believe, my personal belief is the legislature should never legislate what we're supposed to be doing because ultimately they're not responsible. But so I don't have it. I'm still forming the question as I'm talking.
Yep.
But
No.
how do we deal with that? How do we handle that? What do we do? Don't do?
I think it's a great question, and I think it's something that will evolve based upon what the legislature actually does. I think part of the basis of this conversation with putting sustainable investing within a fiduciary framework means it can be handled. Decisions around sustainable investing can be handled some of us would even argue have to be handled within the context of being a fiduciary. That's already been legislated by virtue of you have a fiduciary responsibility. So technically speaking, to your point, there should need to be additional legislation. Now, that having been said, I could name, 23 states that have a legislative mandate for some version of net zero and decarbonization. And if it's not a legislative mandate, it's an executive order. And I think in that case, it gives boards like this board an easy foundation on which to act. So that's what that provides. Whereas, in that process, if this was required, as it technically is in New York State, by legislative mandate, then your grounds to act become much more certain, subject to how defensible the legislative action is in the first place, which is a whole nother issue.
So
But if I might add, though, in California, we have this overlay of our fiduciary duties being in the California Constitution.
Yeah.
And that was the reaction to the whole proposition, or that was Proposition 162 that reacted to former Governor Duke Majan's, Wilson, thank you, grab of certain CalPERS funds.
Yeah.
And that overlays any legislative direction that we may receive with respect to divestment or anything else. In fact, I think the legislature in part recognizes this because in most of these bills, or maybe all of these bills, it inserts what we call fiduciary out, which says if you find that, if the board finds that this is not fiduciary consistent with its fiduciary duties, it doesn't have to do it. Now, there's still an expectation you're going to do it, but so we have that in the legislation, typically in the legislation itself. But even if it weren't there, we have this constitutional requirement that trumps the legislative direction that says it has to be fiduciarily sound.
Right. And I was just going to say the same thing. And almost every legislation that I've seen actually pass in other states relative to this issue, you've seen that fiduciary carve out, which is a recognition that pension funds are trust funds. They are not state funds. And your governance structure was set up, and the governance structure in most states, to create an independent trust board. And so you've seen legislatures, even though they've gone through the motions of kind of interfering with that authority, you've seen legislatures recognize the fiduciary discretion and not interfere with that in terms of the laws that have actually passed. And then from a government relations perspective, it really kind of depends on what your strategy is. But I can tell you that CalSTRS, for example, has a policy where they oppose any legislation that interferes with their plenary authority as board members. And so any legislation that would challenge the discretion of the board to make decisions within its sphere of authority, they just challenge as a matter of course.
Yeah. One of the things that struck me and really I appreciate in this presentation is the recognition, kind of the evolution of things. And for us, for me, one of the real challenges is this is not all, it's pretty challenging stuff to get your hands around, especially when I first came on this board. It was like, wow, the different kind of concept of what a fiduciary is in this context versus others. But now the challenge of communicating that, being really transparent, not just with process, but for our stakeholders who are often driven by, I don't want to say a lack of understanding, but kind of a different mental model of what our role is as fiduciaries. and they come at things, say fossil fuels, from a political or emotional standpoint, and trying to communicate both our process plus where we're coming from as fiduciaries and how any kind of decisions we're making are made on that basis versus also then the science, the objective data. It becomes kind of daunting. And so do you have any advice for us on how we kind of bridge that gap and how to get that discussion back into kind of our turf of, investment decisions, long-term investment decisions? And I have some success with stakeholders by putting it into that framework as risk factors. But any suggestions you have on how we kind of bring them into that conversation on our turf rather than just trying to react to what I find are very compelling kind of emotional or arguments?
Great question that you already sort of answered as well. And that is, you tie it back to the investment decisions that you're responsible for overseeing. And the way to do that is there are a lot of environmental, social, and government issues, and people will come at them from political angles. But at the end of the day, what you're responsible for considering are those that are financially material and have a proven impact on the portfolio and the valuation of the securities within your portfolio. That is inherently the thread through the last three DOL interpretations, regardless of the administration. It all comes back to, if it affects the value of your portfolio, it's material and has to be considered. If it does not, then it doesn't have to, and you might be on shaky fiduciary responsibility for acting in a significant way on something that's not financially material. So that's a way of really honing the conversation down to what is most important for the investment portfolio, and as a result, most significant for the various stakeholders, most importantly, the beneficiaries. Yeah, no.
Just one other thing I would add is, like, your question is like the impossible task of threading that needle, because somebody's always going to be upset with you about something. But I think the challenge for for the stakeholders is and the challenge that we have, because fiduciary duties is complex, right? And so you're kind of conveying a really complex concept to stakeholders broadly. And so I think part of the goal is to inform stakeholders about what the guardrails are for fiduciary duties, and what, like, how you're constrained by those, and but then also to thread the needle and convey information that makes them trust you. Right, back to the conversation around transparency. There are components. The components of trust are care, sincerity, reliability, competence. And so you have to communicate to your stakeholders care, sincerity, reliability, competence. We care about these issues, but within the guardrails of our fiduciary duties, some of the things you're asking us to do are just not consistent with our obligations under the law.
Okay. Any other questions, comments, board members? Seeing none? Okay. Well, yeah, I just want to thank you both and thank Matt, staff, everyone who pulled this together. We have had a lot of fiduciary training that has been very helpful to us, but I think I particularly appreciated how really relevant to our kind of real world issues that we're really grappling with, and really appreciate the insights and the recognition of the importance of the transparency and the diversity of views and stakeholders in this process, because that's right now, I think, what a lot of us are really struggling with. And this has been very helpful, certainly to me, and I'm sure others. So thanks again. Appreciate it.
No, thank you.
With that, I think we were getting close to our break time, so let's take a 20-minute break and be back here at 11:34.
Thank you.